Hi there, and thank you for joining us. Thank you for supporting these Tobin Talks. Thank you for your feedback, and thank you for your subscriptions. Today, we're going to talk about how to take title to investment property. Previously, we've talked about the importance of homestead property. When you maintain a property as your primary residence or homestead in Florida, it's exempt from the claims of creditors other than the government for taxes, mortgages, or material men who improve the house. However, when it is not homestead property, when it's either a second home or an investment property, it is not protected from creditors. You must therefore consider how best to take title in light of creditors. Now, if you're getting a mortgage, the mortgage company will always be first in lien, first in line, first in priority. We ensure that in title. However, if you buy for cash or if you have substantial equity in your property, then you really should be concerned about the claims of creditors. Things happened. In the law, we call it by a different word, but we won't use it now. Lawsuits happen. Lawsuits usually get settled, but when they don't get settled and they result in a judgment then, a certified copy of it at least, can be recorded in the public records and is a lien on real property owned. So when we talk about investment property for the moment, second home is a little different. We'll talk about that at a future date. But when we talk about investment property, if it's rental property to tenants, whether commercial, residential, industrial, you must have insurance and you must require that your tenant likewise has insurance. But even with insurance, you generally don't want investment property in your own name. There aren't as many tax benefits, and from a creditor standpoint, you're better off with it having it in the name of an entity. So investment property, for the most part, is best served when it's titled in the name of an entity. It's very easy in the state of Florida to form an LLC or an S-Corp. LLCs are much more forgiving and flexible with partners and with other things, so they're generally the best bet. When you have an LLC, you take title in the LLC, you make sure that all the corporate formalities are followed, meaning the tenant pays rent to the LLC. The check from the tenant payable to the LLC goes in the LLC's bank account, and you do all your important tax filings at the end of the year in the name of the LLC. You want to make sure that you observe all the corporate formalities so that a creditor can't come after you for what we call ultra vires acts. So we've talked about how to take title for investment property. We generally want to do it in a corporation or an LLC. We must have an operating agreement that sets out the shareholders, the members, the interest, the debt structure, and everything. A disclaimer, this is not a consultation or a substitution for you visiting an attorney. We would love to see you and help you on these things. If it's not us, then someone else, but you must consult on a case-by-case basis. We hope you've enjoyed it. Again, we thank you for all your support and have a great day.